Everyone. I am Princess Rakma Pandato and I will be reporting um, the effects of guarantee and the extinguishment of guarantee. I will be first discussing about the effects of guarantee under Section 2, effects of guarantee between the debtor and the guarantor, Article 2071 to 2072, and then also the Section 3, effects of guarantee as between co-guarantors, Articles 2073 to 2075. Okay, under Article 2071, the guarantor, even before having paid, may proceed against the principal debtor under these instances, these situations given. So, si guarantor, kahit hindi pa niya nabayaran yung amount due sa creditor, pwede pa rin siyang mag-proceed against kay principal debtor na kung saan siya yung guarantor. So, under this given situations, first, when he is sued for the payment. So, kung si guarantor, siya yung pinapabayad ni creditor dun sa utang, then guarantor may proceed against the principal debtor. Second, in case of insolvency of the principal debtor. So, in case na lugi na or wala nang maibayad si principal debtor, so, yun, pwede rin mag-proceed si guarantor against kay principal debtor. Third, when the debtor has bound himself to relieve him from the guarantee within a specified period and this period has expired. So for example, si debtor, sinabi niya kay guarantor na hindi na siya magiging guarantor within 2 years, after 2 years. So if na-expired na yung 2 years na yon, then pwede nang mag-proceed si guarantor against kay principal debtor. Okay, the next one, when the debt has become demandable by reason of the expiration of the period for payment. So kung yung period for payment ng utang ni debtor has expired, for example, after 5 years, yung due ng utang ni debtor has expired, then kahit hindi pa yung nababayaran ni guarantor, pwede pa rin siyang mag-proceed against kay principal debtor kasi nag-expired na or due na yung payment for the credit. Okay, next one, after the lapse of 10 years, when the principal obligation has no fixed period for its maturity, unless it be of such nature that it cannot be extinguished except within a period longer than 10 years. So, kung si guarantor, so after the lapse of 10 years, after 10 years, kung saan yung principal obligation or yung utang has no fixed period for its maturity, walang naka-specified na maturity date or period ng utang, then after 10 years, pwedeng mag-proceed si guarantor against kay principal debtor unless yung obligation na yon is hindi siya mai-extinguished except within a period longer than 10 years. Okay, the next one, if there are reasonable grounds to fear that the principal debtor intends to abscond. So, pwede rin mag-proceed si guarantor against kay principal debtor if there are reasonable grounds na natatakot si guarantor na baka mag-abscond or baka tumakas si principal debtor. The last one, if the principal debtor is in imminent danger of becoming insolvent. So, kung si principal debtor is probable na magiging insolvent siya or magiging lugi siya, then the guarantor may proceed against the principal debtor. In all these cases, the action of the guarantor is to obtain release from the guarantee or to demand a security that shall protect him from any proceedings by the creditor and from the danger of insolvency of the debtor. So, yung mga cases na to, yung action lang ng guarantor is to obtain release from the guarantee. Hindi siya magpapabayad or kung ano pa man, but yung intention lang niya is to obtain release from the guarantee or to demand a security na magpoprotekta sa kanya from any proceedings by the creditor. Okay, remedy of guarantor to proceed against debtor before payment. As a rule, the guarantor has no cause of action against the debtor until after the former has paid the obligation. This is under Article 2066. However, Article 2071 enumerates 7 instances when the guarantor may proceed against the debtor even before payment. So yung nakita natin kanina sa preceding slide, yung 7 instances kung saan pwedeng mag-proceed si guarantor kay debtor kahit hindi pa niya nababayaran yung utang. The purpose is to enable the guarantor to take measures for the protection of his interests in view of the probability that he would be called upon to pay the debt. The remedy to obtain release from guarantee. The guarantor cannot demand reimbursement or indemnity where he has not paid the obligation. So yun yung sinasabi ko kanina na yung intention lang dapat ng guarantor is to obtain release from the guarantee, hindi para bayaran siya or to demand reimbursement kasi nga hindi pa niya nababayaran yung utang. So his remedy is to obtain release from the guarantee or to demand a security that shall protect him from any proceedings by the creditor and for all the danger of insolvency of the debtor. Remember that there are certain cases when the guarantor cannot claim the benefit of excusation under the Article 2059. And in such cases, it is but proper that the guarantor be given the right to proceed against the debtor. So may mga cases tayo under Article 2059 na hindi ma-claim ni guarantor yung benefit of exclusion or yung yung benefit of exclusion, yung hindi mag-proceed si creditor kay guarantor hanggang hindi niya na i-exhaust lahat ng properties ni principal debtor. So in such cases, it is but proper that the guarantor be given the right to proceed against the debtor. Article 2066 differs from Article 2071 in that the former, yung Article 2066, actually refers to the rights of the guarantor after payment. But itong article na to, Article 2071, pertains to the rights of the guarantor before payment. Okay, let's proceed to the next article, Article 2072. If one, at the request of another, becomes a guarantor for the debt of a third person who is not present, the guarantor who satisfies the debt may sue either the person so requesting or the debtor for reimbursement. So let's expand this later. Guarantor of a third person at the request of another. The guarantor who guarantees the debt of an absentee at the request of another has a right to claim reimbursement after satisfying the debt either from, first, the person who requested him to be a guarantor, or second, the debtor. So, kung, for example, si guarantor ay naging guarantor siya ng debt of an absentee, ibig sabihin, wala yung debtor at the time na naging guarantor siya or binound niya yung sarili niya na maging guarantor, no, debtor at the request of another. So may nag-request sa kanya na siya yung maging guarantor dun sa debtor who is absent, who is not present at the time. So if the guarantor has satisfied the debt, then he has the right to claim reimbursement from the person na nag-request sa kanya na maging guarantor or from the debtor. However, see Article 2050 because there are some instances na pwedeng hindi rin alam ni debtor na naging guarantor siya. Okay, under Article 2073, where there are two or more guarantors of the same debtor and for the same debt, the one among them who has paid may demand of each of the others the share which is proportionally owing from him. If any of the guarantors should be insolvent, his share shall be borne by the others, including the payer, in the same proportion. The provisions of this article shall not be applicable unless the payment has been made in virtue of a judicial demand or unless the principal debtor is insolvent. So, right to contribution of guarantor who pays. The obligation of several guarantors is joint. See Articles 1207 and 1208. Each is bound to pay only his proportionate share. Article 2073 contemplates a situation which arises when one guarantor has paid the debt to the creditor and is seeking reimbursement from each of his co-guarantors the share which is proportionately owing him. It is required that the payment must have been made first in virtue of a judicial demand or second because the principal debtor is insolvent. If any of the guarantors should be insolvent, his share shall be borne by the others, including the paying guarantor, in the same joint proportion. This follows the rule in solidary obligations. So let's have an example in the next slide. So here's an example. G, H, and I are guarantors of a debt of 9,000 in favor of C. Ibig sabihin si G, H, and I, sila yung guarantors ni D sa utang niya kay C. If D becomes insolvent, the right of G, H, and I to proportionate division of their obligation ceases as far as C is concerned. C may demand payment of the entire obligation from any of the guarantors. So anong ibig sabihin nito? So di ba si G, H, and I, they have the right to proportionate division. So ibig sabihin kung yung utang ni D ay 9,000, then yung babayaran lang nila is tag 3,000, tig 3,000 lang sa kanila kasi 9,000 divided by 3. However, if D becomes insolvent, ibig sabihin wala nang maibayad si D, then the right of the guarantors to proportionate division of their obligation ceases as far as the creditor is concerned. So, si creditor, si C, pwede siyang mag-demand ng payment for the entire obligation from any of the guarantors. So, si creditor pwede siyang mag-demand kay G ng 9,000, kay H ng 9,000, and then kay I ng 9,000. Kung any of them could be demanded by C of the entire obligation. Hindi na yung proportionate division nila na tig 3,000 lang sa kanila. So, hindi pwede na kung mag-demand ng payment si C kay G for the entire obligation, ang sasabihin ni G ay babayaran niya lang ay yung 3,000 kasi yung proportionate division hindi na yung pwede kasi insolvent na si D. If G pays the whole debt of 9,000, he can later demand from H and I 3,000 each. So, kung pinayaran ni G yung whole debt, yung utang na 9,000, then pwede siyang mag-demand ng reimbursement o ng payment from H and I for 3,000 each. Take note, 3,000 each only. Kasi yun yung proportionate division nila. But if H is insolvent, his share shall be borne by G and I proportionately. So kung lugi rin, kung wala ring may bayad si H, then yung share niya, which is 3,000, then paghahatian yun ni J and I. So ibig sabihin, si G, pwede siyang mag-demand kay I ng 4,500. Naging 4,500 from 3,000 kasi naidagdag yung 1,500 from the 3,000 share ni H na pinakatian ni I and si G. If the benefit of division ceases for reasons other than the insolvency of the principal debtor, under Article 2059, number 1, 2, 4, and 5, the right to reimbursement granted to G against H and I may only be exercised if he makes payment in virtue of a judicial demand by C. For example, a complaint for collection of the debt filed in court by C. Now let's proceed to Article 2074. In the case of the preceding article, the co-guarantors may set up against the one who paid the same defenses which would have pertained to the principal debtor against the creditor, and which are not purely personal to the debtor. So let's discuss this further in the next slide. Defenses available to co-guarantors. In the action filed by the paying guarantor against his co-guarantors for their proportionate shares in the obligation, the latter, which is the co-guarantors, may avail themselves of all defenses which the debtor would have interposed against the creditor, but not those which are purely personal to the debtor. So, for example, in the preceding example, yung kanina, yung kay G, H, and I, so if G sues H and I, the latter, si H and I, may raise the defense of payment by D, by virtue of which the obligation was extinguished. So other defenses such as fraud, prescription, remission, illegality, etc. may also be set up because they are defenses inherent in the obligation, the effect of which is to nullify the obligation or render it ineffective. But if D was so yung defense, si H and I, pwede silang mag-defend, may mga defenses din sila against kay G, such as fraud, prescription, remission, or illegality. So, pwedeng gawin nilang defense against kay G na yung obligation is a fraud. So, kung yung na magiging defense nila, pwedeng hindi na makademand ng payment si G from H and I. So, the effect of which is to nullify the obligation. Kasi manunullify na yung obligation if fraud siya in the first place. But if D was a minor at the time the obligation was contracted, the defense of minority is not available to H and I because it is personal to D. So, kung personal yung defense nila to the debtor, then hindi ito magiging available or hindi siya magiging effective against kay G. And now under Article 2075, a sub-guarantor, in case of the insolvency of the guarantor for whom he bound himself, is responsible to the co-guarantors in the same terms as the guarantor. So, marami-rami ng guarantor yung involved dito. May guarantor na tayo, may co-guarantor, and then may sub-guarantor. So, let's discuss this further in the next slide. Liability of sub-guarantor in case of insolvency of guarantor. In case of the insolvency of the guarantor for whom he bound himself, a sub-guarantor is liable to the co-guarantors in the same manner as the guarantor. So, here's an example. In the example given under Article 2073, so ito yung mga naunang articles, yung example natin nung previous slides. So, if J is the guarantor of I, ibig sabihin may sub-guarantor si I, and I becomes insolvent, nalugi si I, then J is liable to G for 3,000. Ibig sabihin, if nalugi si I, then si J, na sub-guarantor ni I, siya na yung magbabayad ng 3,000, yung proportionate division nila kay G. Or 4,500 if H is also insolvent. If lugi rin naman si H, then yung babayaran na ni J is 4,500 kay J. And now we're done with the effects of guarantee. And then let's proceed to the extinguishment of guarantee, Articles 2076 to 2081. Okay, under Article 2076, the obligation of the guarantor is extinguished at the same time as that of the debtor, and for the same causes as all other obligations. So here are causes of extinguishment of guarantee. Guarantee, being accessory and subsidiary, is also terminated when the principal obligation is extinguished. So kapag na-extinguish na yung obligation or yung utang, then of course the guarantee is also extinguished. So first, here are the causes of extinguishment of obligations in general. The causes of extinguishment of obligations in general, it will be recalled, are first, payment or performance. Um, B, the loss of the thing due. C, condonation or emission of the debt. So parang um, condonation parang pinatawad na nung creditor o hindi na niya pinapabayad yung debtor. D, confusion or merger of the rights of the creditor and debtor. E, compensation and D, F, innovation or my new agreement. Okay, do other causes. Other causes of extinguishment of obligations or annulment, rescission, fulfillment of a resolutory condition, and prescription. But the guarantee itself may be extinguished, although the principal obligation still remains, such as in the case of the release of the guarantor in situations provided in Articles 2077, 2078, and 2079. So the next slides will be about these articles. So for now, for this article, so given na yung causes of extinguishment of obligations in general. So understandable na yan. Okay, under Article 2077, if the creditor voluntarily accepts immovable or other property in payment of the debt, even if he should afterwards lose the same through eviction, the guarantor is released. Release by conveyance of property. So usually, payment is made in money, by cash. But any substitute paid in lieu or instead of money which is accepted by the creditor extinguishes the obligation and in consequence the guarantee. So, if si creditor tumanggap siya ng bayad aside from money or cash, for example, tinanggap niya na bayad is a real property or personal property, then it extinguishes the obligation and of course the guarantee. If the creditor accepts property in payment of a debt from the debtor, the guarantor is relieved from responsibility. This is also true even in case the creditor is subsequently evicted from the property. So kahit na-evict na si creditor dun sa property na tinanggap niya as a payment, then wala nang pakialam dun si guarantor. Eviction revives the principal obligation but not the guarantee. The creditor's action against the debtor is for eviction, and this is different from what the guarantor guaranteed. So if ever man na ma-evict si creditor from the property, then sila na lang yun ni debtor. Wala nang pakialam si guarantor. Okay, Article 2078, a release made by the creditor in favor of one of the guarantors without the consent of the others benefits all to the extent of the share of the guarantor to whom it has been granted. So, release of guarantor without consent of others. So, this happens kapag pag si creditor may nirelease siya from the guarantors, from the payment. So, as a rule, the guarantors enjoy the benefit of division. So, yun yung proportionate division. However, this is under Article 2065. So, however, if any of them should be insolvent, all the other guarantors must bear his share under Article 2073. A release made by the creditor in favor of one of the guarantors without the consent of the others may thus prejudice the latter should a guarantor becomes insolvent. Under the above article, the release benefits all to the extent of the share of the guarantor released. So we have an example here. So G, H, and I again are guarantors for a debt of 9,000. If G is released without the consent of H and I, then H and I would each be liable for only 3,000 or 1/3. So, ibig sabihin, if si G ay nirelease ni creditor, without the consent of the other guarantors, si H and I, then yung babayaran lang or yung amount na liable by H and I will only be the 3,000 or yung 1/3. Yung original na proportionate division nila sa debt. H and I are benefited to the extent of 3,000 the share of G. So wala na silang pakialam dun sa 3,000 na dapat sana ibabayaran ni G. Kasi nirelease naman siya, no? Creditor. If the release is made with their consent, the H and I will each be responsible for 4,500 or one half. But, so, here's another instance. If the release is made with their consent, ibig sabihin alam nila yung pagka-release ni G, then may dadagdag sa kanila yung 3,000 na dapat sana ay babayaran ni G. Ibig sabihin, pagkahatian ni H and I yung 3,000, that is equals to 1,500 for each of them. So, may dadagdag yun sa originally na 3,000 na proportionate division. So, ang mangyayari, 4,500 na yung babayaran ni na H and I. Responsible. So, if G is released with the consent only of H, however, kung si H lang naman yung may consent or yung may alam na na-release si G from the that, then only H is liable for 6,000. So, yung 3,000 na babayaran sana or responsibility ni G will be added to the responsibility of H. So, magiging 6,000 na yung liability ni H instead of 3,000. Samantalang si I, 3,000 lang yung kanya, the original proportionate division. Okay, under Article 2079, an extension granted to the debtor by the creditor without the consent of the guarantor extinguishes the guarantee. The mere failure on the part of the creditor to demand payment after the debt has become due does not of itself constitute any extension of time referred to herein. So, let us discuss this further in the next slide. Release by extension of term granted by creditor to debtor. Okay, first, we're released without consent of guarantor. So, ito yung hindi alam ni guarantor, yung release or yung extension. If the creditor grants an extension of time to the debtor without the consent of the guarantor, the latter, which is the guarantor, is discharged from his undertaking or his liability, his responsibility. The reason for the rule is the necessity of avoiding prejudice to the guarantor. The debtor may become insolvent during the extension, thus depriving the guarantor of his right to reimbursement. So, what is the reason for this rule? For example, si creditor, binigyan niya si debtor ng extension pero hindi alam ni guarantor. Ang mangyayari, yung extension na yon hindi na doon kasali si guarantor. Ibig sabihin, tapos na yung pagiging yung guarantee ni guarantor prior to the extension. Kasi, if ever na during that extension period maging insolvent si debtor, hindi magdi-deprive yung guarantor sa right niya to reimbursement. So hindi na makaka-reimburse si guarantor from the debtor sa if in case man na babayaran ni guarantor yung debt. So to save the guarantor from this situation, then the guarantor is discharged from his liability or his responsibility if the extension granted by the creditor is unknown to the guarantor. Second, extension must be based on new payment. The extension of the term must be based on some new agreement between the creditor and the principal debtor by virtue of which the creditor deprives himself of his claim. Hence, the mere failure to bring an action upon a credit as soon as the same or any part of it matures does not constitute an extension of the term of the obligation, and therefore the liability of the guarantor is not extinguished. So, for example, nagbigay nga si creditor ng extension, but it's based on new payment or new agreement, then it does not extinguish the liability of the guarantor. The reason for this is that The right of the guarantor would not be prejudiced since he could avail himself of the right granted him under the Article 2071. So, uh, yung kanina na Article 2071, yung 7 instances, pwede din yung gamitin ni guarantor if ever man na um, if, pwede yung gamitin ni guarantor kahit hindi siya nagbabayad. So yung 7 instances under Article 2071, namely to ask the debtor for a release or to demand a security. So in this second paragraph, hindi extinguished yung liability ni guarantor. While dito sa first paragraph, extinguished yung liability ni guarantor. Diligence on the part of creditor to enforce his claim. If the creditor had done any act whereby the guarantee was impaired in its value or discharged, such an act would have wholly or partially released the guarantor or surety. In the matter, however, of suretyship, the creditor is under no obligation to the guarantor or surety to display any diligence in the enforcement of his rights as a creditor. So magkaiba yung instances ni suretyship at ni guarantee lang. The creditor's mere inaction, indulgence, passiveness, or delay in proceeding against the principal debtor, or the fact that he did not enforce the guarantee or apply in the payment of such funds as were available, constitutes no defense at all for the surety, unless the contract expressly requires diligence and promptness on the part of the creditor. The guarantor or surety is not discharged from his undertaking. And now we're last to we're up to the second to the last article under the extinguishment of guarantee. So Article 2080. The guarantors, even though they be solidary, are released from their obligation whenever by some act of the creditor they cannot be subrogated to the rights, mortgages, and preferences of the latter. Released when guarantor cannot be subrogated. So the guarantor who pays is entitled to be subrogated to all the rights of the creditors. That is under Article 2067. If there can be no subrogation because of the fault of the creditor, as when the creditor releases or fails to register a mortgage, the guarantors are thereby released. The same rule applies even though the guarantors be solidary. So if yung isa sa mga guarantors, binayaran niya yung debt, then usually entitled siya to be subrogated to all the rights of the creditors. However, in cases where si creditor na yung may fault, such as when the creditor fails to register a mortgage, then ibig sabihin na wala na yung liability ni guarantors. Guarantors are thereby released. So, wala na silang babayaran dun sa co-guarantor nila na nagbayad ng debt. The same rule applies even though the guarantors be solidary. The rule is founded on the principle of law that the act of one cannot prejudice another. So, kasalanan lang ni guarantor na binayaran niya yung ni isang guarantor na binayaran niya yung utang na hindi niya alam na may fault si creditor. Okay, now this is the last article under the extinguishment of guarantee. Article 2081. The guarantor may set up against the creditor of all the defenses which pertain to the principal debtor and are inherent in the debt, but not those that are purely personal to the debtor. So this article is about the defenses naman ni guarantor against kay creditor. So let's see the next slide. Defense available to guarantor against creditor. The defenses available to a debtor as against a guarantor are provided in Article 2068, and those available to co-guarantors in Article 2074, yung kanina, kuha natin. Article 2081 provides for defenses that may be interposed by the guarantor as against the creditor. So ito namang article na to is yung mga defenses naman na pwede gamitin ni guarantor against kay creditor. Inasmuch as the guarantor against whom the creditor seeks payment takes the place of the debtor, it would be absurd and unjust to deny him the defenses of the latter, because the guarantor, who is only subsidiarily liable, would be put in a worse position than the debtor, the one principally liable. So, kung si creditor, so parang sinisingilan na niya si guarantor, then of course, since si guarantor parang tinake place na niya yung yung pagiging debtor, parang siya na yung naging debtor, then it would be unjust to deny him the defenses na para kay debtor. Ibig sabihin, pwedeng maging defenses ni guarantor yung defenses ni debtor against kay creditor kasi siya yung sinisingilan ni creditor. So, that's it for our extinguishment of guarantee.